Good afternoon, everybody, and welcome to our Ardea International series on human rights due diligence. I can see that a number of participants are now beginning to log on, so I'll just give everybody a moment to get their IT sorted, to get comfortable, get your cup of tea, sit back and relax while the rest of us do some thinking. So just as a welcome, I'm really delighted to be able to be hosting another one of our webinar series, and I'm particularly delighted to be joined today by our speakers. Again, we have a real range of speakers with great expertise. I have the privilege of having worked with both Lee and Felicity and previously collaborated with iPoint Systems, so a real welcome to Sebastian as well. In respect of how we're going to work today, I'm just going to be doing a general welcome. So my name is Colleen Theron, and I am the CEO of Ardea International and a tri-qualified lawyer. And we've been running this series for the past year, really trying to shine a light on what we mean practically by human rights due diligence, and trying to get in as many different experts to really hone in on this subject area. In relation to housekeeping points, we will be recording this webinar. It will be available on the website afterwards if you'd like to listen to it again. We would like to welcome questions and answers if you can pop them in the chat, and we will try and answer them all before the end of today's session. For those of you who are still signing up, welcome to today, and I hope you are going to enjoy it. Just very briefly, so in relation to the speakers, as I said, each one is going to introduce themselves properly, so I won't go into detail about Sebastian, Lee and Felicity now, but only just to say thank you for their time, and I'm really looking forward to their insights today. About Ardea, we are a specialist sustainability, business and human rights consultancy with expertise in modern slavery. We work internationally, we work across sectors, and we support organizations in the development and review of their policies, and particularly the implementation of their due diligence systems, as well as meeting legal compliance obligations, and underpinning all of this with training. So before I'm going to hand over to Sebastian, there are just about 4 or 5 slides that I wanted to share with you, particularly around today's subject. As you know, that what we're going to be discussing are some of the geographical challenges around human rights due diligence. And I think that with the speakers that we have today, you're going to get some really interesting insights around what these particular challenges are in relation to sourcing, sector, gathering evidence from workers, understanding exploitation. From a legal point of view and a best practice point of view, I think going back to basic principles, we need to remember that human rights due diligence is an ongoing risk management process. And the process is there to identify and evaluate human rights risks. I think what is quite critical to remember too, as part of setting up a due diligence framework, is that the response that an organization has to be both reasonable and prudent. So what we mean by that is it's completely inefficient for a FTSE 100 company, for example, to just have no established policies or no robust procedures that underpin any commitments in relation to due diligence. That just wouldn't be seen by reasonable and prudent, and that has been tested by the courts in the context of health and safety. So it is really getting to grips about the size of your company, what's reasonable and what is prudent. And then it's a question of what the steps would include. So the steps that I've highlighted here come from established due diligence frameworks of the OECD, which sets out requirements to assess actual and potential impacts, to integrate and act findings, to track responses, and to communicate how responses are addressed. Now, for those of you who are listening, I'm quite sure that most of you are aware from our previous webinars or from other webinars that you may have attended, is that there have been a number of voluntary frameworks that have been created to establish principles for responsible business to adhere to in the way that they address and manage human rights impacts. The UN Global Compact is a membership organization, so it's not like the UN Guiding Principles, which are a set of principles. It does have 10 principles, which companies that sign up to the UN Global Compact agree to adhere to and to communicate on their progress. And of course, we have the SDGs, which have been agreed at a government level, but that we increasingly see are being adopted by companies as part of their overall objectives, and particularly also in relation to human rights, of how they're going to address poverty or modern slavery or gender or diversity issues. But the critical issue that we have with with voluntary frameworks is, of course, that they do not have proper enforcement mechanisms, and the incentives to join them are not always clear. And as a result of the kind of failure, I would say, of the voluntary frameworks, we recognize that it has been recognized that there needs to be legislation that is put in place that governs the behavior of corporations and how they address human rights. And I borrowed the slide from somebody from yesterday. I was speaking at a Seafish Foods meeting on mandatory human rights due diligence. But I liked it because I thought it gave a really sort of nice timeline around how the due diligence requirements have gathered pace and the kind of changes that we're seeing. And I think, you know, to highlight what we have here is this tremendous growth in domestic legislation that is setting out requirements for companies on either how they report on how they manage their human rights impacts, both potentially and those that have been identified as actual impacts, and how they actually are carrying out due diligence to ensure that those impacts are managed well. This is just another slide setting out, again, that timeline. And as you'll see, and I guess what I wanted to also draw out from this particular slide is that the distinction we have now is that whilst we have some legislation that is reporting legislation, so you report on the steps you're taking, like the UK Modern Slavery Act and the Australian Modern Slavery Act, what we have increasingly is actual due diligence legislation. And the mandatory due diligence legislation that we're going to be looking at coming in at an EU level is designed really, I think, to try and level the playing field more when you think about the distinctions that are now being drawn between different jurisdictions like the Netherlands, like Switzerland, like Germany and France, where there are different requirements that are being set out in the law for companies on how they undertake the management of human rights in their supply chains and in their own organizations. And then just finally, or two more slides, just very, very quickly from my side. When we hone in on geographical regions as a challenge, we don't only have the challenges in legislation. I think the other elements that have to be taken into account by organizations is where they are operating. So the nature of the governments, whether there's conflict, is there the rule of law, is it established? What are the sectorial challenges? You know, for example, when you look at things like the cocoa sector or cotton, for example, you know, very, very complex supply chains. How do you trace where your raw materials are coming from when you have a number of intermediaries, you know, and that's increasingly a challenge as the law is requiring you to be able to actually report and demonstrate that you have a handle on how you're going to be managing your processes. Abuses of human rights by topic. So when you're looking at geographical regions, you have different challenges depending on the regions you're in. It might be child labor, it might be migrant workers, it might be issues around forced labor. So there are lots of different challenges depending on where an organization is operating. And alongside that are the cultural challenges. And I don't think one can underestimate the impact of those distinctions, because to try and do a one-size-fits-all, for example, remediation process is never going to work. One really has to have an understanding of the issues by topic and the cultural issues that are involved in relation to managing your human rights. I think that we're not seeing as much due diligence carried out on business relationships as perhaps they could be. I suspect that that's something that's going to grow as people's awareness of the risk in this area increases. I think we particularly need to get organizations to understand what is meant by leverage, what they are able to manage in terms of influencing relationships. And then, of course, the use of data is really critical. And I know Lee's going to come in on this, as so is Sebastian. From an Ardea perspective, we have developed a due diligence, forced labor due diligence and ESG due diligence system, which is based on a data platform and as a means of helping organizations mitigate their risk, which we're excited about. And I apologize, I've just seen that my slide with anti-slavery is upside down. So for all of you getting necks that are having to turn, I'll try and fix that when we, if we want to share the slide. So again, that's just an interesting source of, you know, kind of products and commodities that could be tainted by child labor and forced labor if you're looking for a starting point. And then my final slide, just some thoughts about how you might prepare for human rights due diligence. For some of you who have listened to my previous webinars, this particular slide might not be new to you. Always good to reinforce learning. I think the 6 points I've raised here are just ones that I've seen to be quite useful to organizations that we've worked with over the past 8 years in relation to due diligence. And I have set out that I think is really critical to document and understand what your human rights due diligence regulations are, to identify what processes you actually have in place, to consider whether those processes align to both the law and international standards, to assess what additional data or evidence you may require to produce your disclosures, to ensure you have a cross-functional team. I mean, working in silos is just a nightmare. You cannot address something as complex as human rights due diligence in silos. There needs to be cross-functional, cultural input, corporate culture input into this. And then finally, understanding your risk and understanding how you're going to mitigate it. So I know I've rushed that, but I really want to allow for the time for the others to really come in and hone in on their discussion on this. So Sebastian, if I can please hand over to you, and I know you're going to share your slides, so I'll stop sharing and let you take over now. Thank you.
So welcome everybody from my side. You can see my screen, correct? Yes, great. So a warm welcome from my side, from Berlin. I'm joining here and I am working as a project manager for the company iPoint Systems. Just some brief introduction what we're actually doing. We are helping and empowering companies to collect and analyze all necessary information and data which they do need to assess and to report environmental, social, and economic impacts on their products and also on related processes. So this means we are trying to help to automate and to digitalize processes for data collection and analysis. Today, however, I want to speak to you regarding a particular German development that some of you might have already got news about, which is the now newly introduced German Supply Chain Due Diligence Act, and what we maybe can learn from this German legislation for the forthcoming European legislation. For you as a short introduction and to put this into context, we have seen from Colleen the slide with the timeline of the different regulations. And this German law is basically the transposal of one of this voluntary guidelines and frameworks, basically, which is based on the UN guiding principles, so the so-called Ruggie framework. And this voluntary mechanism of the UN guiding principles has 3 pillars, which are to protect human rights from a state side, to respect human rights from a company side, and to provide an access remedy. So on the protection from the government side, this is already, let's say, in Germany in place. But what we were missing is, let's say, the respect or the legal base for this respect and access remedy. So there was the introduction of a voluntary plan for German government companies to comply with this. However, as a result, there was seen that this compliance with this voluntary mechanisms was not wide adopted by German companies. So the government decided that now there needs to be a German mandatory law, which, let's say, introduces these requirements to companies. And this is what I would like to give you a short introduction today. So what is this law about, and like who is affected by this law? As some background for you, the legal status is currently that the legal act was passed in summer, in July 2021, so really fresh, this regulation by the German Parliament. However, it will only take effect on 1st of January 2023. This means by this date, you need to have like your first report in place. So companies need to start already now thinking about how they want to address this topic in 2022. Even though the law only comes into force in 2023. Who is affected by this law? These are nationally operating companies in Germany. And as you can see, originally it was planned that it only affects German companies. However, this has changed. So if you have a subsidiary in Germany, which has more than 1,000 employees working in Germany, this affects you. If you are a German company who has, let's say, a subsidiary which has only 50 employees, we have the so-called holding approach. This means if your mother company or parent company has in total more than 1,000 employees, this law also affects you, even though your subsidiary might only have like 50 employees. So this is like already a mechanism where they want to avoid that you create a subsidiary only in order, let's say, to avoid this regulation. And in the first year when it will be introduced, it will only affect companies with 3,000 employees. But in 2024, it will be, let's say, reduce the threshold to all companies which have more than 1,000 employees working in Germany will be affected by this. What is the focus of this regulation, of this law? The main focus of this regulation is the own company and direct suppliers. So when we're talking about supply chain due diligence, you are thinking about like sub-suppliers and sub-sub-suppliers. So really complex, maybe to the mine somewhere in Africa. This law is only directed and asks the companies to execute due diligence on their own company and on the direct suppliers in order to address that you only have a certain kind of influence over your supply chain. What kind of risks are addressed in here? So what companies need to monitor? There is a list in the law, which includes, as some might say, let's say there's usual suspects. So we see that companies need to address certain risks, which are child labor, forced labor, health and safety, freedom of association, discrimination, and also minimum wages. I have highlighted minimum wages because I have linked here the English translation of the law, but there's a translation error. It does say living wages in the translation, but in the German original, it's speaking like about minimum wages. And this is, let's say, some difference that maybe the translator didn't knew, but has, let's say, a significant impact. It also addresses, apart from human rights, also environmental aspects, and this is derived out, let's say, of different international agreements, which is, for example, mercury, persistent organic pollutants, e-waste export for the Basel Convention, but also kind of, let's say, air and water pollution and excessive water consumption, for example. This is also addressed in this law. What does this exactly mean? It's not specified in the law. This is then something that a court needs to decide when you're speaking about excessive water consumption, for example. Apart from the risks that need to be addressed, the regulation does require companies to introduce a so-called risk management system within. And some of you who are already familiar with these kind of human rights processes within companies will see that a lot of these different steps are, let's say, already familiar friends. This means this is, let's say, basically all kind of risk management approaches that we already have seen at OECD guidance, for example. So here, if you have already an OECD aligned risk management process in your company, this is then, let's say, a good start in order to comply with this law. This means you have like a risk management, risk analysis. You need to introduce a supply chain due diligence policy and process. You need to install prevention mechanism and processes at your direct suppliers, provide remedy measures, grievance mechanisms, and you need, of course, to execute the due diligence obligations to your direct suppliers and have, let's say, some documentations and reporting to competent authorities. The regulation and the law does not require public reporting, only public supply chain policy, but you need to report to the competent authorities. When we're looking into this law, this is a German law for German companies. So you have a problem executing German national law in other countries, right? When you are like addressing this to your suppliers, because this is not within your own country. And for this reason, the law addresses the obligations that we see here in the requirements. It does establish a due diligence obligation or a duty to effort or of effort, and not a duty to succeed. So what does it mean if you have child labor in your supply chain with this law? This law does not sanction it. Like you cannot be sued based on, let's say, that you have child labor in your supply chain. However, you can be sued, or let's say you are infringing this law when you're not establishing these requirements that you see here, and that you are establishing a risk management system. So this is, let's say, some very important distinguishment that you need to do. It's only a duty of effort, but not a duty to succeed. Just some further information for you. There is a quite strong market surveillance on the competent authorities. So there are planned 65 full-time employees to execute and to monitor this law, which is kind of unseen in this form previously. And we have, let's say, penalties which can go up to 2% of the annual revenue. So which is quite, let's say, a high penalty if you are not complying with this regulation and you get sued. Very interesting when we're looking into the remedy pillar is that you have also the possibility now for lawsuits. So that NGOs and local unions, for example, in Bangladesh, can sue a German company based on this law on behalf of infringements in the supply chain for the workers. So this is a new possibility was now introduced. And this is, let's say, to honor the remedy and the access to remedy from the UN guiding principles. What do we see now in practice? We see that now companies are already starting requesting their suppliers to fulfill this requirement. We see this first request that they're asking, what is your high risk materials, for example, which are associated with human rights violations? Do you have some transparency about your supply chain, where this material is coming from? And what we are seeing is that they're asking to establish this transparency. So this is what we are currently seeing already in German supply chains, in industrial supply chains, that this is the first results of this law. And we will be sure that this is only the start, and it will get, let's say, much more pressure, let's say, from the companies who are affected by this law. This is as a small insight for you. What I want you also to know is, let's say, what can we learn for the European Supply Chain Due Diligence Act and further initiatives? So just, let's say, some overview about, let's say, what is the current discussion state of the European law? And what I want to give you is, let's say, about the current draft. And the current draft is only the Parliament's draft, not already the EC or like the European Commission draft, which is expected soon. That we are seeing that, let's say, the German and the European law do have some let's say, aspects and comments. But for example, for the European law, we see that they have also a requirement for supply chain mapping and stakeholder engagement, which is missing in the German law. So this, like, just as an overview for you to compare and what to expect. But we see they are quite similar. It's a little bit more detailed on the German side here, the sub-steps of the risk management. But what you can basically expect is that in the basic structure, maybe the European law might be very similar to the German one. It does not end there. The European Union or the Commission is now also discussing, in addition to supply chain due diligence, now some extension about regulations on sustainable corporate governance. This is currently a consultation which is ongoing. We're also expecting that the Commission will soon publish here some draft report. So when you're getting started, and you need to comply with this law, it will not stop here. We will see that this, at least on European Union level, it will get, say, more and more stricter. And I think this is, let's say, the journey that we're heading to. So I hope that you got like some short insight into this European and also the German law, and I'm happy to answer your question afterwards. Thank you.
Sebastian, thank you so much. That was so authoritative and incredibly insightful. I think it's particularly helpful also having your local insight into the actual interpretation of the law. And I think for lawyers, that's particularly worth knowing. You know, I mean, to make a distinction between minimum wage and living wage is very, very different. If you are in practice for a number of organizations, that could have quite a material bearing on how they address things. I have questions, but I think I'd rather come back to that at the end and allow Felicity to perhaps come in now. I think, Felicity, you're next. And Felicity, you are not sharing slides, am I right?
That's right, yeah.
Okay, so Sebastian, can you just stop sharing? Thank you very much. And I just let Felicity take over. Thank you, Felicity.
Thanks, Colleen. So yes, welcome everyone. And to introduce myself, I am the Ethical Trading Manager for Clothing and General Merchandise at Morrisons. And I've been working in human rights and sustainability in the garment industry for a bit over 10 years now. So I'm going to go through some reflections on that time. So to set the scene a little bit, traditionally, the fashion industry has had very low barriers to entry because you don't need complex machinery and highly skilled workers to start making t-shirts. That means it tends to be present in countries which are just beginning to develop economically. And that therefore also means countries with less developed protection, pay, and conditions for workers. And without going into the history of the multi-fibre arrangement and quota chasing, world trade agreements have also contributed to apparel production being spread out across the globe. And so, as we've gone through the past couple of decades, fast fashion in the global north has played a key role in the history and economic development of quite a few other countries. So China was one of the initial production powerhouses with endless streams of available labour. But as the economy has developed and crucially the middle class and therefore domestic market in China has grown, circumstances have shifted. So you now increasingly have manufacturers in China who are looking inwards rather than to export markets. And of course, the workforce has changed, labour costs went up, and that precipitated a push to sourcing from other countries. But even with the wage rises, many people no longer want to work in factories as other industries are seen as being more prestigious. I always find it interesting when the same problem plays itself out in different ways. So in the UK, people are leaving the hospitality industry in droves, but in China, it's a very attractive employment proposition. And meanwhile, as this happens, the majority of retailers are still trying to keep on top of these shifts through ethical audit programs. And audits in China have generally always raised issues with high working hours and low social insurance participation. But now workers often hold the upper hand and are dictating the hours that they want to work, which are still generally higher than the legal maximum. Previously, this would have been hidden by double bookkeeping by the factory, so it doesn't come through on audits. But as we all gradually move towards better understanding and transparency, this is happening less often. retailers are realizing that burying their head in the sand about what's really happening isn't contributing any value to their business. But equally, the traditional tools we've had to manage risk in our supply chains, like audit, don't feel like the best fit to understand and to work with different regional contexts. And then the other powerhouse of garment production is, of course, Bangladesh. So here you have a country that is built on the back of garment export. And as China did, they have a seemingly endless stream of cheap available labour. There are always more people to throw at a problem. Traditionally, they have also had pretty limited labour union membership, and over the years there have been some well-documented issues with health and safety, with high working hours, and with child labour. And brands' early efforts on due diligence, which was really not due diligence but just policing this, didn't help. In the example of child labour, efforts to eradicate this from garment factories were very successful. But while there is poverty, child labour will always exist. So what's happened is that it's been pushed further down the supply chain and into other, often more dangerous industries. Then, as time has moved on, we've had new players, countries like Ethiopia, like Cambodia, Myanmar, although the latter has obviously had some very recent changes in circumstance. One of the key differences here is that they have less domestically owned manufacture. Much of it is foreign direct investment from India, the UAE, China, Japan, often garment manufacturers there who are expanding into countries with lower wage rates. From a due diligence perspective for brands, this complicates things further as we become part of a longer chain of actors who are all exploiting conditions in another country. And how do you draw a clear line between exploiting and exploitation? We need some very clever tools to be able to do that. Another shift that's happened is that the world has just become much smaller. It used to be quite easy to have a very kind of us and them mentality, and generally with brands holding all the power in that relationship, but that is not a forward-looking approach. If you look at something like the Accord on fire and building safety in Bangladesh, that started from a place where brands were being held to account for something incredibly horrific that happened in their supply chains with the collapse of the Rana Plaza building and the death of over 1,000 people with thousands more injured. But now the building safety programme is run by a tripartite structure of brands, unions, and the Bangladeshi garment industry. Now, as has been mentioned today, brands need to actively respect human rights, both by avoiding causing adverse human rights impacts, but also by mitigating adverse impacts that are already happening. But that act to remediate those impacts is not something that you should inflict on your supply chain. It's something that you need to work with them on. And as well as the danger of an us and them mentality, another dangerous way of thinking is in terms of just good and bad. You can't be that binary when you're working with people who might have fundamentally different beliefs and cultures or a view of the world. But to work with people across the world effectively, you need to understand them, which is not a simple task. I have neighbours in my street that I get on with, but I wouldn't get into a detailed discussion about Brexit or mask wearing and vaccinations with them. And I have to acknowledge that that's because I am so entrenched in what I believe to be the right thing that I'm not really prepared to try and understand their point of view. But to work in human rights, you need to get past that. And when you're potentially in the minority on someone else's turf, you need to get past that with humility and respect, no matter how much it strikes at the core of your value system. Being a one-person woke police is going to get you nowhere. And then on top of that potential for a fundamental clash of values, you throw in language and cultural barriers. A really classic example that I always enjoy hearing people's stories of is going out for a meal with suppliers or with people you work with when you're on a trip. It is such a simple premise, and yet I have heard endless permutations of how this has turned into a dramatically egregious meeting of different cultural norms. So to give an example of analysing approaches to a problem, to a need for due diligence. Going back to the issue of low social insurance participation in China, many brands are pushing factories to increase the amount of workers included in these schemes. From the workers' point of view, they would often rather have the cash in hand because they're migrants, they're sending money back home. The East Coast can be effectively a foreign country to them. They may not be familiar with the systems and processes to be able to access the benefits once they're back in their home province. And if they want, they can arrange a cheap insurance policy for themselves once they're back home anyway. So I do question if I'm doing quite the right thing, because I'm pushing for something because it's the law and because I'm very used to the NHS and state pensions and these things feel good and right. But equally looking for common ground, I fully understand someone not having much trust in the government and not liking wage deductions. And this is something that's obviously incredibly topical in the UK right now. I'm sure we're all looking forward to our increase next year. And I understand wanting to have control over your own future and your financial security, and potentially not having that much belief that there actually will be a state pension by the time you need it. And I can't predict the future to guarantee that participating in social insurance will actually benefit someone financially in their specific circumstances. And even from the stance that it's the law, well, there are other Chinese laws that I vehemently disagree with. So I genuinely don't have an answer on this, but I know for sure that maintaining an attitude that my values are right and theirs are wrong is not going to make any progress. So where does that bring us to? I've brought up some examples of where social auditing has failed to really mitigate adverse human rights impacts. And I've talked about the importance of having the right approach and mindset to successfully interact with people across the globe, although to be fair, that is equally applicable to your colleague or next door neighbour. Human rights due diligence in the garment industry is now following this shift kind of away from black and white, good and bad, finding a neat list of non-conformances in an audit and then telling the factory to go away and fix them. It's moving to almost a move back to first principles in the UN guiding principles, to fundamentally trying to understand what are the rights and needs of people in our supply chains and how are our operations impacting those. And to really understand that, you need to listen. And at the end of the day, people are not so different. We mostly all want the same things, but respecting cultural context is key to directing how you make progress. So at Morrisons, we are just starting some project work now to develop a more needs-based approach. So to let our supply chain partners tell us what they need rather than us telling them what they're doing wrong. The UNGPs talk about the importance of leverage in complex supply chains. Well, as long as you are dealing with people, then listening, understanding, empathy and relationship building will get you a lot more leverage than any other approach.
Felicity, thank you so much. Just so insightful to have your corporate experience and your voice around this. And I think, you know, we don't often hear the real sort of basis of relationship building, and as you say, the listening and the understanding, and I just think that, you know, I want to thank you for that, because I think probably if we had more brands, more corporations really embracing that kind of approach, we might find that a number of the really trickier issues are dealt with in a slightly better fashion. And I know certainly I see Lee is also nodding her head. You know, certainly we very much uphold collaboration, understanding as being, you know, a really critical element of how you transform change and how you are impactful. So I really want to thank you for that. I think that was incredibly insightful. And if I can now hand over to Lee, I think Lee, you're going to be sharing the screen, so I'll hand over to you. I just want to say we've got a flood of questions that have come in. I'll try my best afterwards to respond to them. What we might try and do is actually, because a number of them are sort of quite thematic, is to see whether we can produce a short frequently asked question guide after this. I think that might be quite useful. Lee, over to you.
Great, thank you. I'm so pleased I'm going after Felicity. She's provided a brilliant preamble in terms of the critical role played by listening in proper due diligence. I think we often mistakenly associate due diligence with policing, and actually proper due diligence is all about collaborative action and listening. So basically I'm chief exec and founder of Ardea. It's a company that conducts due diligence and monitoring across 38 countries for kind of over 50 clients now, and we do quite a lot of due diligence work in different sectors. We most active in apparel, FMCG, construction and energy, but also present in other sectors. And what we do there is we aim to make invisible working conditions visible by generating insight on working conditions and worker well-being using mobile tech. And using that mobile tech, essentially workers are invited to receive a call, participate in an online survey, or accept a WeChat invite to answer 20 simple single literal questions. And this whole exercise is all about listening, essentially, all about gathering feedback from workers directly and anonymously in particular workplaces. And we'll talk more about the selection of those workplaces later. But long story short, that insight from workers lands on these traffic light dashboards, where every site is classified as either red, an urgent picture, amber, mixed picture, or green, fine. And of course, there's further detail on particular priorities on that site level and progress just a click away. So that's the system. How does it fit into the bigger picture of human rights due diligence we're talking about today and the geographical focus? So essentially, insight and monitoring forms one of 5 capacities we often advise in the clients we work with. And I'd like to kind of talk you through those capacities quickly before moving on. The first capacity, speaks to a number of points that have already been raised, and that capacity is all about, being clear, having the clarity on what your biggest human rights risks and biggest human rights opportunities are. I mention opportunities kind of stubbornly here because I know with due diligence we usually associate it with risks only, but I think it's a huge missed opportunity not to also, consider the human rights opportunities, given that you, of course, down the line, you're going to be expected to do your ESG reporting or sustainability reporting with good data in the picture. So clarity on the biggest human rights risks and opportunities. Secondly, management systems that speak to those. Not management systems that it's just a checklist situation and that everyone else has code of conduct, contractual requirements of supplier assessment system, and maybe a grievance mechanism that they offer at the corporate level. No, make sure that the management systems you have speak to your biggest human rights risks and opportunities. Thirdly, yes, insight. And the insight and monitoring piece is different from the typical management systems, in that often, for example, one of the management systems that is typically used is social auditing. In those management systems, you get kind of fragments of information, can be very, very rigorously conducted, but it's associated with a particular point in time, particular setting, particular point in time. Monitoring essentially offers you a continuously changing picture such that you can kind of log in and check the kind of working conditions picture across all your suppliers in a particular geography or subsector at any point in time. Now, in that third capacity, what you want when it comes to monitoring is, of course, again, to speak back to your biggest human rights risks and opportunities. You want to monitor using the metrics that reflect those biggest risks and opportunities, and to use such to continuously measure and manage those risks, and of course, nip them in the bud and address them promptly when you spot an urgent risk, but also to constantly kind of cumulatively understand your human rights impact. Fourthly, response protocol, it's great to have the insight via monitoring and of course the kind of more time-specific insights from audits and individual incidents through grievance reporting lines. But it's important before you gather any of that insight and look at any of those assessments to have a response protocol in place. What the hell is a response protocol? It's essentially knowing what you're going to do if and when. So if a particular type of indicator is flagged as urgent, then the company has decided that the following actions, manageable, feasible actions, will be taken, or one or more of the following actions will be taken in order to address that particular X. So that's a response protocol. It's a simple matrix to say, if the following indicators are flagged on our monitoring dashboard, then we're going to do A, B, and C. But that's just a protocol. And the fifth capacity is about actually having, the people, the mandate, and the resources in place to actually take action according to that protocol. It's fantastic to have insight, protocol, and management systems and some clarity on what you need. But if you don't take any actions, the kind of remedy and response itself, aren't in the picture, and you're not going to improve the picture and be able to address what's flagged. So there, to Felicity's point, it's a lot about equipping the team to deal with, those cultural interactions and cross-cultural interactions, but also to have the skills and mandating resources available to act when needed. When we look at monitoring and the kind of direct work reporting and wider conducts in the due diligence process, essentially we always follow quite a scripted process for due diligence with our clients. And that can be described in 4 stages. We actually often describe in 3, but I'll mention that later. But the 4 stages are essential steps. The first is that desktop risk assessment, and it's part of that clarity on biggest human rights risks and opportunities. But here, when we conduct due diligence for clients, we often advise that they deploy quite a rigorous system of looking at the risk for each and every supplier in their most risky sourcing geographies and for their higher risk supplier profiles. So they take that particular kind of list of suppliers and they push it through a facility like Subsidiaries. So Subsidiaries is US-based. And they have huge databases, watch lists, etc. And essentially it allows you, it gives you an output for every single business you enter. And that output is telling you whether that particular business appears in a particular watch list or sanctions list or NGO report, or whether by virtue of ownership, upwards or downwards, there's a related entity that appears in a watch list or sanctions list, etc. And that kind of spits out a particular risk profile per supplier, and we add 4 indicators to that that draw on your social audit reports. And essentially, step 1, takes your longer list of suppliers from the higher risk geographies and shrinks it down to a shorter list of suppliers that require deeper due diligence. And step 2 is about getting the metrics, checking that you've got the metrics and response protocol in place before you start monitoring that shorter list of suppliers. Step 3 is pushing play on the monitoring. We engage with those businesses and start monitoring using direct work reporting, that worker engagement system that I mentioned earlier. Once the results have dropped, supplier, the business itself, as well as the buyer, receive the dashboard as they always would. And we give a parallel report, often verbal, to the client or retailer, to say, by the way, in terms of forced labor, highly sensitive indicators, this is how the business has fared. And if the business is essentially coded red, according to the kind of sensitive issues, or even on the general dashboard, then frequently our clients choose to push it into stage 4 of our due diligence process. And that involves a partner. Frequently speaking, this is a partner that has, or actually it always is a partner that has the capability of making on-site visits, and importantly has the experience to help you with with negotiating an exit and if necessary, but with taking next steps when it comes to remediation and addressing the issues that are found on the site. So it's a kind of it's quite a comprehensive process where you start with quite granular risk assessment, then get data directly from the site via workers, and then potentially engage in an on-site visit. So that's the 4-stage process. What I've missed out here, which is a pity, is that we work quite closely with different partners. One of which actually is Pauline and Ardea, and they often provide fantastic support for our clients on the response and remediation protocol. And so that's it from me. In short, it seems like quite a lot to take on board, but actually it just gets back to some basic common sense with due diligence. That you need to have the right priorities. You need to know what your priorities are in terms of human rights due diligence, the right process, right insight, and the right support, the right partners by your side. So thanks for listening. Looking forward to hearing your questions.
Thank you, Lee. That was very insightful. I think and particularly, honing in on the fact that having the right priorities really actually, for organizations to not be dealing with this in a very haphazard way, because I think that often can happen. People become reactive to a new law or a crisis or some sort of short-termism, and actually perhaps the changes in the legislation, what we're seeing coming up is an opportunity for organizations to just take stock of where they are. I think kind of going back to one of the slides I had is really getting to grips with what you have in place and what are your objectives, and then how will you address that. Right, so I have so many questions that have come in, and it looks like for a number of them they relate to Sebastian. Some of them I think might be around questions also for just trying to see if there's something for Felicity and generally for us. If I can perhaps start and ask you, Sebastian, one of the questions they've asked is, when the German law will come into force in January 2023, does that mean companies will have to report on 2022 activities or 2023 activities?
Yeah, thank you very much for the question. This is like a good question indeed. So it's even written within the law that the first reporting, which needs to be filed in 2023, needs to reflect the year 2022. So this means basically you need to start now to prepare, let's say, the activities so that you have them in place in 2022 so that you can report for them on 23.
Thank you, Sebastian. And actually, just to follow on that question, there have been a few questions around, I think the point that you made around parent companies and then subsidiaries within Germany. Is the position that if the question we have here is, when a mother company has several subsidiaries in Germany, is it required to submit a single report or individual ones, even for subsidiaries below 3,000 or 1,000 employees? Is that something you can answer?
If there is like one report that separates reports, I cannot answer by now. I think maybe that needs to be, let's say, directly figured out with the competent authorities. I can think about that. Maybe you can agree that you will have like a joint report together, but basically then also the law affects you. It's just, let's say, the entry, when does the law affect you as a company? Also, let's say the employees of your associated companies, parent companies, are also taken into account.
Okay, that's helpful. And I'm just looking to see, I don't know, maybe this is a question, perhaps Felicity, for you. Do you think there is a heightened level of due diligence in conflict affected areas?
I would strongly advise carrying out a heightened level of due diligence in conflict-affected areas, certainly for all the obvious reasons. If there's a total breakdown in the rule of law, then how can there be any protection for anyone operating in that space? Equally, how do you operate effective due diligence, that needs to be something to consider very carefully.
Yes, thank you. Does anyone else want to, Lee, would you like to comment on that particular question?
Sure. We've had a few experiences where clients have said, of course, we can't engage currently, this was a little while ago, we can't engage currently in Egypt because of the kind of disruption, because of the political kind of turmoil. And I completely understand that. But that's when you need a toolbox that includes remote monitoring and remote, assistance for reaching the site and continuing to conduct due diligence even when on-site audits, etc., aren't possible.
Thank you. Sebastian, is that something that you come across at all in your data collection, particularly something that you're seeing with the work that you do on conflict minerals, is considering sort of heightened due diligence in those particular areas?
Yes, of course, indeed. There is, let's say, when you're looking into the space of responsible mineral sourcing, there are so-called CARAs, conflict affected and high-risk areas. There is, let's say, also related to the European regulation, a list of those high-risk areas where companies are asked to, and of course, this is, let's say, where the risk lays and where you need to really, let's say, focus your attention on.
Thank you very much. That's really helpful. I just wonder, there is a question from someone to Lee, to yourself and mine, about how do you see calls for hard law strategies for potential liability for social audit firms in addition to corporations, especially in situations where they rely heavily on social audit firms? Is that a question? Perhaps the person asking this wants to just clarify if the question is that social audit firms are going to be held accountable in the same way as corporations, or is there a problem in relying heavily on social audit firms? I'm not entirely sure what that question is alluding to.
I think maybe what's being asked, but Usman, please correct me if I'm wrong, but it is, if social audit firms aren't themselves being particularly rigorous with due diligence and they miss significant issues, and like with Rana Plaza or like in other settings where kind of gross human rights violations were taking place and they were missed, are they liable? Are they legally liable for such? And do we see any hard laws coming in that might make them legally liable? Frankly, because I'm not the legal expert, Colleen is, I'll defer to you.
I know. I think that's quite a difficult question. I just think that that's going to be based on contracts and what kind of specs are set up in relation to your social auditing firms and what they carry out and fulfilling their requirements. I mean, certainly there is more scrutiny on social audit firms. There's more disciplinary action that is being taken for social audit firms that don't audit properly. And I think to the extent that if you are a social audit corporation, so a global organization falling within the requirements of any of the local jurisdiction laws that we're talking about, either Modern Slavery Act in the UK or the German Supply Chain Act, you are also going to be bound internally to be seeing that your own operations actually meet those requirements. So I think hopefully, Usman, that goes some way towards answering that particular question. We've only got a minute left, and I think perhaps the last question, if we just want to have a comment on it, is Sebastian, do you know whether civil claims can be brought against a German company on behalf of other affected parties like communities, or is it a mechanism to protect just workers or suppliers? Is that anything you're aware of?
Yeah, I think it's a tricky question. So I think first of all, to keep it short, a civil claim is something that, from my interpretation, and I'm not a lawyer, so please treat this with care. There is no base for civil claims in this law. There's only a base for implementing and executing the due diligence efforts within a company. there is the instrument of this lawsuit for affected companies, if you're affected by these. I think this is only for, let's say, for those subjects who are directly have this infringement of this law, like child labor or minimum wage. And this subject are, to my understanding, not communities, but single individuals. So I think communities are not entitled.
Okay, thank you very much for that. Well, I think we've now come to the end of our hour. I really hope that you found it informative. I've certainly learned a lot. I must say thank you hugely to Lee, to Sebastian, to Felicity for the time you've taken to prepare and to actually deliver your speaking slot. So thank you to everyone. Thank you to all of those of you who listened. Do look out for our next 2 webinars that are coming up for the rest of the year. We'll be putting them on the website in the coming weeks. And just one last thing to flag, we have a new Stop Child Labour online training program that's we're looking to pilot. I'm interested because the German Supply Chain Act has very specific requirements around child labour. So if you are interested in participating in that pilot, please do just email me afterwards and I can send you some details. So wishing you all a fabulous week. Thank you for your time. God bless. See you again. Bye.
Thank you.
Bye-bye.